please your Lordship and your Lordship, I appear on behalf of the General Counsel in the appeal, the appellant in this matter, and my learned friend Mr Kennedy appears on behalf of the registrant Mr Aga. The court should have before it, I think uncontroversially, a core bundle which runs to 12 tabs and 138 pages.
Yeah.
A supplementary bundle of 4 tabs running to 70 pages.
Well, let's just take this one slowly, because I ended up with what seemed to be a lot of bundles, and then I found some duplications in some. So let's just be absolutely clear.
Yes, I'll slow down, my lady.
No,
I'm
no,
sorry.
it's all right, Mr Hare. I've got 2 supplementary bundles. I've got a supplementary bundle which runs to 6 dividers, and it's 86 pages.
Yes, that
and
one.
I've got a supplementary bundle amended, which has got 4 documents in it and runs to 70 pages.
Yes, so the first one you took up there,
Yep.
my lady, was lodged by the GDC as the supplementary bundle, and then we were told off because it had some further documents that weren't.
Yeah. Yeah.
We were told off.
Right.
And so we then had to put in the application for the fresh evidence bundle,
Yep.
which means that the supplementary bundle now should just have 4 tabs in it and run to 70 pages.
Right, that's that one. And then
So
the
the other
fresh
one could
evidence
be
was taken out, and you put in the review determinations, haven't you?
Yes.
And some consultation documents and the application for fresh evidence.
That's it.
Right, okay.
And then there's an authorities bundle.
Yeah.
Which runs to 13 tabs, 295
That's-
pages.
yeah.
I think. Yes.
14 tabs I have in mind.
Oh, because of the certificate. I'm sorry, my lady. Yes, you're right. 13 authorities. Really, there are 2 other matters. So your Lordship's referred to the fresh evidence bundle. There's also the matter of our supplementary skeleton argument, which I need to.
And that's dated the 6th of December.
It is.
Yep.
We put that in because obviously there'd been some time since the replacement skeleton arguments were put in April. Some water under the bridge, including the review hearing that Mr Aga had and the consultation. So it's slightly dependent, I accept, on the fact that we're seeking to have the fresh evidence put in. But that's what the supplementary skeleton argument does. It doesn't seek to advance any new arguments.
No.
I understand there's no objection from my learned friend, but
Well, that's correct.
Thanks, Mr Kennedy. Right.
and the other matter then is the fresh evidence bundle. Your Ladyship's referred to that. It has 2, as it were, categories of document in it,
Yep.
going through in terms of the Ladd-Marshall principles, as it were. None of those 4 documents was obviously available at the time that the initial hearing took place in front of Mr Justice Ritchie. We do say they're relevant. We don't say they're likely to be determinative, but we do say they're relevant because one issue, of course, that we make, one of the arguments, is that if you do treat an immediate order and the substantive suspension as being part of the same suspension, that may mean that there isn't sufficient time for remediation. And we say that's what these reviews actually demonstrate, because at the first review it was found that Mr Aga hadn't remediated and further work was required by him. That's the first 2 documents. The second 2 documents are consultation, which the GDC was undertaking in any event, but does have 2 paragraphs which address how the GDC at present proposes to deal with what's said to be the unfairness arising from the operation of the current rules. I'll come to that in due course, but again we say it's relevant to issues in the appeal. Finally, we say both of those sets of documents are apparently credible, and we invite the court to admit them. Again, I don't understand there to be any objection from a learned friend.
My lady again does not.
Thank you, Mr Kennedy. Very well.
Thank you. There's then the matter, I think, Mr Kennedy, do you want to stay on your feet, Mr Kennedy? Because, no, not at all.
So, Mr Kennedy, I've got a respondent's note in response to the supplementary skeleton argument and the supplementary bundle. And in fairness to you, Mr Kennedy, you're clearly seeking to assist the court as to the decision of Mr Justice Morris, his reference there to the Medical Act, and explaining what in fact was happening.
That was all it was intended to do. It was something, in fact, I raised in my skeleton before the High Court for reasons not immediately clear to me it didn't go into my skeleton before this court. It's something touched upon also by the judge below. But I think it's easier to be understood as explaining what Mr Justice Morris says in paragraph 253, where he talks about it. And I confess on my first reading of him, I wondered whether his reference to the Medical Act was in error. I don't think it was.
Yeah.
Hence, it seemed to me it might help just to have some information about what was driving the change. So that was all it was intended to do, to try and assist the court.
Well, I'm sure we're all very grateful. Any issue on that, Mr Hare? No. Very well. Thank you very much indeed, Mr Kennedy. Right.
Thank you very much, my lady. I'll be relying obviously on the supplementary skeleton argument from now on rather than the replacement skeleton argument. I'm not proposing to read that out, but...
Well, and can I just say this? The court has read, I'm not going to say every page of every single document in this case, but we have read extensively.
Right, thank you. I'm very grateful for that. My submissions fall into three parts, really, my lady. The first of all would say something very briefly about what the issue in the appeal is, but the court will be well aware of that from its background reading in any event. I then wanted to say something, again briefly, about the factual background, and I did want to take the court, if I may, to the Practice Committee's determination, or at least certain aspects of it, again, very briefly. And then come on in the third part of my argument to the substance of it, which, as the court will be aware, is really threefold, our challenge to Mr Justice Ritchie's judgment below. The first of which is that Mr Justice Ritchie, with respect, misconstrued the relevant provisions of the Dentist Act, in particular those three provisions, 27B on directions at the end of the fitness to practice process, section 29A on when directions take effect under the Dentist Act, and their interaction with section 30 on immediate orders. That's the main thrust of our argument, and we say if we're right about that, then we win anyway. The second and third parts relate to aspects of what we say are fundamental features of the professional disciplinary landscape. One of those I've referred to already in relation to the fresh evidence bundle, which is the aim of ensuring that registrants are able to remediate identified impairments to their fitness to practice and have the time and inclination to do so, not when they've got an appeal outstanding, which they think might vindicate them and therefore remove the need to undertake any further reflection or remedial work. And secondly, we say the overemphasis with respect that the learned judge placed on fairness to the registrant when construing those provisions of the Dentist Act. We say in professional disciplinary proceedings it's clear that the starting point is the protection of the public, and that is the main motivating factor behind interpreting the relevant
Lord Bingham.
I'm sorry.
That's Lord Bingham.
Yes, in Bolton and Law Society, and repeated many times since. Yeah. And we say in any event, the alleged unfairness to the registrant, in this case and in most cases, is in fact overstated. And that is again, my lady, I referred again previously to the fresh evidence we seek to rely on. In that fresh evidence, as I hope I'll show the court, there's a proposal as to how the General Dental Council will seek to mitigate any unfairness, to which we say the natural reading and clear meaning of the rules, the Act, give rise.
Mr. Hare, there's, just to check this, one ground of appeal.
Yes.
Which is Ritchie J got it wrong.
Yes.
And then you articulate that with three headings or three arguments in your skeleton, but you've both adopted that structure, the argument structure of looking at those three things a little bit separately, but they all converge on a single ground.
They do.
Okay.
Yes, that's correct, my lady. Thank you.
And this is an appeal. I know it's directed at the General Council, but in fact it has implications for other professional disciplinary bodies too.
Yes.
And that I acknowledge when permission to appeal was given.
Indeed. Yes, that's correct. Almost all of the other medical or healthcare regulators have almost identical provisions. The exception is the Nursing and Midwifery Council, where the provisions are slightly unusual. And I'm not proposing to say very much about the authorities, in fact, no more than a couple of lines, really, in due course, because, of course, it's a matter for this court to decide, and no one suggests there's any binding authority on this court as to what the correct answer is. But one point I will make, and perhaps I can make it now, is that one does need to be a bit cautious reading the NMC cases, the Nursing and Midwifery Council cases, because under their rules, the Nursing and Midwifery Council Order 2001, both what is called an interim order under the Dentists Act, that is to say before you get to the practice committee, as it were, to protect the public when the investigation started but before you get to the hearing, and what in the dental context is called an immediate order, that is to say the order made after a direction, but to fill the gap between the direction taking effect and or whether there's an appeal.
It's the 28 days.
28 days, yes. And if there is an appeal until the appeal is determined. Both of those in the NMC structure are called interim orders. And they're both under the same article of the NMC's order. And that has created, we say, some confusion in the Camberova case and other cases, where it's not quite clear whether the judges are referring to an interim order as it would be in the GDC context or the immediate order. But that's the only real point I wanted to make about it. But otherwise, of course, your lordship's quite right. Certainly the General Medical Council, most of the other regulators have what are in substance identical provisions. And most of them adopt the same nomenclature, that is to say, distinguish between these three different types of order: an interim order, a direction, which is the substantive sanction. I've called it the substantive sanction. I accept that's not in the Act, but I did that in order to try and make it sort of clear, distinguish it from the other interim or immediate orders, and an immediate order. And it's really the interrelationship between those that this court has to address, subject to the fact that I don't think there's any dispute now that in relation to an interim order, it's not relevant to this case, of course, because there was no interim order in Mr Aga's case. But it seems to be clear now on the authority of the Adil case that in an appropriate case, depending what the purpose for the imposition of the interim order and then the direction of suspension was, that it may be appropriate to have regard to the fact when you come to decide how long, say, a suspension should be by way of substantive sanction.
That would typically involve consideration of what use the registrant had made of the time when he was under an interim order.
Precisely, yes.
Yep.
Yes.
So if you... There's nothing to prevent, for example, on a review under the dentist scheme, the dentist saying, well, not only have I put the 9-month period to good use, but actually even before then I had made good use of my time. In those circumstances, there would be nothing wrong in principle with the reviewing committee saying, well, we've taken everything into account, including that, and that leads us to the following conclusion: he needs another 3 months, or he's done enough, or whatever it may be.
He's no longer impaired, yes.
No longer impaired.
Yes. Yes, and so at the review or resumed hearing, they could then terminate the suspension.
And the mere fact that he'd used the time either of an interim or an immediate suspension productively might of itself be indicative that he is remediated.
Yes, yes. The only caveat I'd express to that, my lord, but I accept entirely what your lordship says, is that, of course, in relation to an immediate order, if that's ongoing while the registrant is appealing against it, depends on the nature of the appeal, of course. But if the nature of the appeal is that I didn't do anything wrong, then the registrant might not be very inclined to undertake any remediation, which might be taken as an admission that he had done something wrong or could improve. But subject to that.
It could be tricky, but you could dodge that bullet.
Yes. Yeah.
I mean, the registrant could dodge that bullet.
Certainly.
By saying, well, I don't accept I've done anything wrong, but
yes. Just in case.
for the future I'm going to make sure, doubly sure, and so on and so forth.
Yes, and I've taken this course and done that training and so on, yes, and reflected, and here's the statement I produced by way of reflection, yes. Yes. Thank you very much, my lord. So that's the issue. The court's very well aware of what the issue is, and that's what it is. I don't want to waste the court's time by explaining what the issue is when the court clearly has it. Can I move on to the second part of my submissions, which is to say something about the background? Now, the factual background really doesn't matter at all. It's summarised by the learned judge below in paragraph 7 to 19 of the judgment, which is obviously in the core bundle. And those paragraphs are between pages 52 and 56. We certainly have no real issue with the way in which that's put. It did involve allegations relating to harassing a dental nurse with whom Mr Aga wished to have a sexual relationship. And can I just, I indicated I'd do this, and I hope it's not taking the court out of its course, but just to have regard briefly to the decision of the practice committee. It's in the core bundle, beginning at page 125, and this is the decision of the Professional Conduct Committee between the 18th and 21st of July 2023, so core bundle 125.
Speaking for myself, and I mean speaking for myself, I found it a particularly clear decision. Relevant detail, one understood.
Yes.
While we're handing out the plaudits, what I don't think is in there is a clear statement of a finding that he wanted a sexual relationship.
No.
That I think, I'm not doubting it, and maybe there was material underneath it, but it wasn't, as I recall, something that was specifically found. Correct?
Thank you, my lord. I think Mr Kennedy's going to... He was obviously there below, so...
That was something of a bone of contention. That was an inference rather than there being any positive evidence to that effect.
Yeah.
I confess I cannot
But
remember
it doesn't matter for present purposes.
It doesn't matter.
But it just occurred to me that Mr Justice Ritchie had gone beyond the four corners of the findings.
There were two aspects which caused concern. That was one, and the other was a reference to stalking, because stalking is a particular offence which was not the offence that Mr Aga was charged with. He was charged with harassment. But they're very, very fine detail points which I don't think take us a great deal further. But yes, those are, in terms of plaudits, yes, there's maybe two observations to make.
Thank you very much. The court will see the charge and how it's dealt with. So on page 126, I will take this quickly, my lady, but on page 126, paragraph 5, there's reference there to the admissions that were made by Mr Aga. There's the point there about knew or ought to have known. And charge 4 in relation to dishonesty, which wasn't found to be made out. It then conducted the usual pattern, of course, factual inquiry, then determination on misconduct and impairment, and then determination on sanction. And on page 127 from paragraph 20, which is towards the bottom, the court will see the heads of charge there set out in bold and italicized, and the finding, if a finding's needed, if the matter wasn't admitted, below that over the succeeding pages, just so that the court understands what the 5 heads of charge were. And that takes the court down to page 130, where the committee moves on, as it says at the bottom of page 130, to stage 2, that is to say its consideration of misconduct, and then moving on to consider impairment. And the relevant paragraphs there, we say, are under the heading misconduct, which begins on page 133. So under that heading, it's the paragraphs over the page, beginning at paragraph 64 on page 134. If I may just read that out. In the committee's judgment, the course of conduct which you pursued in the summer of 2020, which you knew would amount to harassment, was in clear breach of the standards expected of any professional person. It is conduct which was so serious as to meet the threshold for misconduct. That's what they say in relation to that. And then in 66 and 67, they address charge 3, failure to inform the GDC of the criminal charges until January 2021. Find that that was misconduct 2. And at 67, in respect of charge 5, the restraining order that was made against Mr Aga, the committee determined that this amounted to misconduct as it was a serious matter. Then at the bottom of 134, they turn to the question of impairment, beginning at paragraph 69. And these are really the passages I wanted to highlight to the court, if I may, beginning over the page at paragraph 71. As part of the factual inquiry, going back to the first stage of the committee's determinations, you denied that you knew that the course of conduct you were pursuing amounted to harassment. You only admitted that you should have known. 72. The committee found that you did know that the course of conduct which you were pursuing in June to August 2020 amounted to the harassment of person A, and then sets out its justification for that. I won't read all of that out. But then 73 to 76 contain the following. 73. Your evidence to the committee during the factual inquiry demonstrated a lack of insight into the seriousness of your conduct and the impact it had on person A and her family. Much of your response to the questions put to you was either deflective or centred on the impact this matter has had on you personally, rather than acknowledging the impact on person A and her family. 74. The committee noted also that on the 3rd of May 2022, you applied for the restraining order to be lifted. This also appeared to be indicative of an ongoing lack of understanding of the impact this application may have had on person A. 75. The only evidence of remediation which you put before the committee was evidence of a 4.5-hour continuing professional development course on professionalism. You did not provide any corresponding written reflections on any learning from that course and on how any such learning has been embedded. Finally, 76, the committee was struck by a stark lack of meaningful insight and reflection. And then I said finally, didn't I? I shouldn't have done, sorry, 77 over the page. The committee considered your misconduct to be attitudinal in nature and therefore more difficult to remedy. You do not demonstrate remediation, and the committee considered there was a real risk of repetition. And then it comes on to, so that's impairment. It then comes on to sanction a little further down that page, beginning at paragraph 80. And goes through, as usual, starting at the bottom, working its way up. And at 88, it addresses the direction of suspension. In the committee's judgment, a period of suspension with a review would be sufficient to protect patients and the public insofar as your professional standing as a dentist would grant you access to them, and to maintain wider public confidence in the profession. A period of suspension would be sufficient to mark the seriousness of your misconduct, and to allow you further time within which to demonstrate further reflection and remediation, and to develop insight into the impact of your behaviour. I therefore direct at 89 a 9-month suspension with a review, and then at 90, as one frequently sees, the committee there gives an indication of the sort of material it thinks would be helpful on review in order to demonstrate that the registrant has addressed those matters which led to the finding of impairment.
Yeah, they're obliged to do that, aren't they, when they provide for review?
By guidance, by guidance, but not by law, I don't think.
By guidance?
By guidance,
By
yes.
guidance.
Yes.
Thank you.
Yes, encouraged.
Encouraged, yes.
It's all right, Mr Kennedy. I found it very disconcerting when I began to sit as a judge how much can be heard, and I did wonder how much had been heard over the years as an advocate.
Thank you. That's the direction. There's then, as the court is well aware, a separate exercise under a separate part of the Dentists Act, but the same committee, and as it were as part of the overall sanction determination, where the committee turns its mind to whether or not there should be an immediate order, and we see that 91 to 93.
And you see, there's the separation, isn't there? They've taken all the relevant steps in terms of misconduct, in terms of impairment, misconduct and sanction. They give the direction and then they stop.
Yes.
And then they move on to submissions on what really is the Section 30 point.
Yes. So they stop, and they announce their determination, stop, and then invite submissions from the parties as to the question of an immediate order. So there's a further, you don't see it from this, of course, you see it from the transcripts, which we don't have.
There must be a gap between 91 and 92.
There was a gap. Yes. Sorry, that is the gap. I'm sorry. Yes, it's represented here by a thick line, isn't it? But there was, in fact, a short adjournment, and submissions were made by both parties, and then the committee considered it and came back and delivered its determination. The only other point I wanted to make, and this goes to my final point, as it were, about questions of overall fairness. It's not said, and it couldn't be said, that a registrant is not aware of what the effect of undertaking or issuing an appeal is. They're informed of it at the hearing, and we see that in paragraph 93, that if they do appeal, the 9-month period of suspension will not start until the appeal is determined. And that you don't have it in the bundle, I'm afraid, but I'm sure the court has seen a number of examples of this. But the letter that the authority is required to send to a registrant, informing them of the outcome and informing them of their right of appeal, also states if you do decide to appeal, then the immediate order will carry on until that's determined. So to the extent that the fairness concerns are raised about that, we say this registrant, and indeed all registrant, couldn't be in any doubt about what that effect would be. Mr Aga, of course, did appeal, and he was perfectly entitled to do so. He has a full statutory right to do so. He appealed on a number of grounds. There's been some toing and froing between my learned friend and I about precisely how it was put below and whether Mr Kennedy initially advanced a challenge on the basis that you should treat the 2 periods of suspension, both the substantive suspension under the direction and the immediate order, as being part of one suspension. I don't suspect that the court's very interested in that. I certainly accept that Mr Kennedy did challenge the immediate order. It's clear that he did that, and that was heard along with the appeal. So we don't dispute that. But our reading of the principal basis of the appeal was that it was a challenge to the proportionality of the 9 months on the basis of the findings of the committee that there was a risk to others apart from person A, and it was said on behalf of Mr Aga that insufficient weight had been attached to his testimonial evidence. So that, we say, appeared to be, you'll hear from Mr Kennedy in due course, but we say that appeared to be the real thrust of the appeal. But in any event, the issue was plainly raised, even if it was raised mostly in response to a request by Mr Justice Ritchie for it to be addressed further in written submissions. The issue was raised about what the interaction should be between the direction for suspension under Section 27B and the immediate order under Section 30.
Well, I'm sure Mr Kennedy can help us on that. I'm not asking necessarily now, but my reading thus far is that although there was a challenge to the immediate order, it wasn't on precisely the point that the judge seems to have taken. Is that fair?
That is fair, and my learned friend has been more than generous to me in the way he's described how I put the appeal. I think to be entirely fair, the appeal was put purely on the grounds of proportionality. Conscious of the way that forgive me if I'm taking a moment, just conscious of the way that the established practice works, I, with my appeal, put in an application for termination. And that part of my skeleton which dealt with this issue, if I can put it in the broadest sense, was directed at why an application for termination should succeed, rather than to a challenge to the issue that now arises.
Set-off point.
To either the one suspension or set-off point. And so it was, out of fairness to the court and the council, it was an issue which was raised effectively exclusively by the judge, but I think on the back of the unfairness that I had pointed out in my skeleton.
Mr Kennedy, don't read into what I'm saying as there being any criticism, because there is not. But my reading of the position is that although you took the point properly protecting the interests of your client on proportionality, the point that is now really before this court came from the judge.
It did.
Yeah.
It did.
That's right. That's how I read it.
Thank you very much. And we can see it reflected in the judgment, which of course the court has in the core bundle beginning at page 50. I think the most relevant passage is paragraph 31, page 62. About halfway down, the paragraph 31 begins, the appellant submits that, the correct interpretation, etc. And then about halfway down, perhaps 6 lines, this point was raised as a concern by the appellant. And you've heard from Mr Kennedy what he says about that, but not dealt with in the parties' skeleton arguments. Therefore, I ask both parties to research the issue and provide written submissions after the end of the hearing. So of course, I'll come back to the learned judge's reasoning, but I'm still going through the background at the moment. But while the court's there, could I just say perhaps the shortest way of capturing it is just to turn on to page 87 of the core bundle and paragraphs 96 to 97 of the learned judge's judgment. I'm not going to read those out, and I'll come back to them, but the court's obviously read them already. The point there is that the judge is saying on a proper reading of the legislation, there's really only one suspension, and therefore the upper limit in the Act in section 27B of 12 months is an upper limit in relation to the combined effect of both an immediate order and a direction for suspension in an appropriate case. And that, of course, is reflected in the learned judge's order, and perhaps I could just ask the court to turn to that. It's core bundle, page 48 to 49. This is the, yes, core bundle 48 to 49, the order stamped 28th of December 2023, and the first 3 paragraphs of that. The 9-month suspension was quashed. Then 2, there shall be substituted for the direction a direction that the appellant shall be suspended for a total period of 9 months, from which the duration of suspension already served under the immediate suspension order shall be deducted. The direction imposed on it shall be reviewed, and then 3 is for a review before the expiry of the period of suspension.
Mr Hare, before we leave this order, what about paragraph 4? The court has looked at it.
Yes.
I'm not going to say we wholly understood it.
No, I didn't understand it.
Is it a typo?
Is that the order
Should
that
it
was
be
made?
the other way round? That is what I thought, my lady, but I'm afraid I haven't asked.
Is it just wrong, Mr Kennedy? Should it be the other way round?
No. No, I was ordered to pay GDC's costs.
Why?
Because my appeal failed. My substantive of the view I took.
So your
my
substantive appeal,
had failed,
but you won on the point that the judge had pulled up,
which I hadn't argued.
Who agreed
Right.
£11,000?
The parties.
Okay.
I'm doing this, I'm afraid, from memory, but I'm pretty sure that's right. Yes. I think it was a bill and an offer.
Right, well, thank you. Are we taking you totally off course, Mr Hare?
No, not at all. No. And it wouldn't matter if you were, my lady. But, yes, so that's the order. In accordance with the order, I referred to paragraph 3 there about the review. In accordance with the order, there was then a review, and I've put that in the fresh evidence bundle, and I wonder if I could just show the court that, please. So fresh evidence bundle, tab 1. This is the first review of the 17th of April, 2024.
It's tab 2.
sorry, tab 2 because the application is tab 1. I do apologise. The way I've sort of noted it down, it helped me, but the court's probably there already. So I made note in this sense of the dates, as it were. So what happened was on the 21st of July 2023, the Professional Conduct Committee imposed the direction for a 9-month suspension and made the immediate order. The High Court hearing and order, the High Court order was the 28th of December 2023. By that stage, of course, the registrant had served a little bit more than 5 months of a suspension subject under the immediate order. The order of the judge then, with effect from the 28th of December 2023, was that he should serve a total of 9 months, which would have ended, therefore, at the 21st of April 2024. That would be 9 months from the Practice Committee's original, the Professional Conduct Committee's original decision. And in order for there to be a review, as the court can see, that review had to take place before the expiry, and it took place, in fact, on the 17th of April 2024. And that's the document we have there. And you'll see the parties and the representation and so on. I'm not proposing to take the court through it. A large part of it is just summarising what had happened before. But if we go to page, if I can invite the court to go please to page 10, under the heading Today's Review in bold, just above paragraph 13, you'll see there some matters are redacted because they're in private, and there's reference to the registrant having some problems with
Where it says private, does it? I had read that as meaning that what comes afterwards, then what comes immediately afterwards is private, because that's...
Yes.
So it's not redacted in the sense of being struck out.
Not for your purposes, no. So in other words, perhaps I should say it's been put back in, as it were, for your purposes. But yes, that would come out. The references to health conditions and so on would come out. And there's another reference a little bit further down. Then there are some submissions by the representatives of the parties. And then we come on to the decision on current impairment, which begins at page 13, paragraph 35. I'm not going to read all of that out, but what I invite the court just to sideline it. I think we would say it was proper to summarise it by saying that the committee was not satisfied that Mr Aga had undertaken sufficient reflection, developed sufficient insight, and taken sufficient steps to remediate the matters which led to the imposition of the direction of suspension, and that therefore the current period, and I'm looking here at 48, the committee therefore determined that the current period of suspension should be extended by a further period of 4 months, beginning with the date on which the present order would otherwise expire. A review would be appropriate in the circumstances. It was satisfied that this would provide you with an opportunity to continue to develop your insight and provide evidence that you fully understand the impact of your misconduct on person A. It would also provide you with an opportunity to demonstrate any learning you've been able to achieve to reduce the likelihood of repetition of such conduct in the future. So, in a sense, this comes back to the point my Lord Justice Stuart-Smith made earlier on, that it may well be, and I'm not suggesting this is the case about Mr Aga, but it may well be the case that a registrant with a strong belief that they have been unfairly treated or inappropriately treated or disproportionately treated by the General Dental Council or other regulator, as it were, stands firm on that while their appeal is determined. And then it's only after, and if their appeal is unsuccessful, that they say, okay, well, I now have to face the prospect of getting back on the register. There's a review. They won't let me back on the register unless they're satisfied that I'm no longer impaired. So I'd better start that process. And we say if you do aggregate the 2 periods, you prevent that process running its natural course. The natural course that the Professional Conduct Committee considered as an appropriate amount of time, both to mark the seriousness of the conduct and to give Mr Aga the opportunity to remediate, was 9 months. And in the time from December to April, it appears that he hadn't done sufficient. And that decision, of course, is not one that was challenged. By the time we come to page 16 of the same fresh evidence bundle, 26th of July 2024...
Pause there.
Sorry.
the PCC add on another 4 months.
Yes.
He's already done 9. So on Mr Justice Ritchie's analysis, they must be acting outside their powers.
Yes.
Because they've breached the 12-month cap that he says applies.
Well,
willy-nilly.
I think it might be said, Mr Justice Ritchie might say, if an immediate order is imposed following a direction, there's the full cap of 12 months. But on a review, the provisions in section 27C give a fresh power to impose a suspension up to the 12 months.
Okay.
So I don't think that would have been a point
Okay,
that
so
could
you're
have been taken.
so your reading of Ritchie is that it's the aggregation of the, I always get it the wrong way around, but the immediate order combined with the first period of direction, of suspension direction, that's
Yes.
the one you've got to keep an eye on.
Yes.
But then it would be okay for PCC to come along and say, we're going to give you another dollop of up to 12 months.
So long as they're
Substantive.
sorry, yes, so long as they're satisfied that there's still a problem with of impairment.
Thank you very much. That's on Ritchie. Can I just ask you
Yes.
a question now or at some point? Is there a long stop when you can, just as background, can you
No.
just keep on? Can the PCC carry on adding 12 months?
Oh
please?
no, well no, it can only add another 12 months. Then it has to go to court to get that extended.
That's
go
right,
to the High
that's
Court,
right, that's right.
a statutory application,
Thank you.
and then it's up to the court, which I think this varies, but I think the court can authorise up to another 18 months, but usually it's less than that.
And you can go back to the court again.
Yes, then you go back to court again, and you can.
Someone's shaking their head behind you. Whether they're involved or not, I don't know.
Oh, sorry, that's for. I'm so sorry. So. I see. Sorry. Yes, I'm sorry. So it's the interim orders that you go back to court to get renewed. So in relation to these orders, it would be open to a professional conduct committee to continue to impose 12-month periods of suspension at a time. It would then come back for another review, and it would have to decide again, still impaired, and we're going to make another 12-month order. Each of those are appealable, of course, by the registrant, but there may well then come a point at which the GDC would invite the Professional Conduct Committee to make a permanent suspension order.
I see.
I see. So,
Sorry, I'm sorry for the confusion.
no, it's all right,
I
Mr.
said
Hare. Let's just get this one clear. You've got the initial period of 12 months,
Yes.
the 27
B.
B,
Yes.
12 months. Then you can come back for a review,
Yes.
which can extend or rather impose a further period up to 12 months. Is your position now that at the end of that second period of 12 months, there's another review and that still has power to impose a further period of up to 12 months?
Yes.
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 We're looking at 27C.
27C.
Yeah.
Yes.
And so under 27C1, on a resumed hearing, they can either say suspension terminated or extended by another period of not exceeding 12 months.
Yes.
And then I think where we're talking about at the moment is D, little d, if the person's registration in the register, that the person's registration in the register is suspended indefinitely if the period of suspension would have lasted for 2 years and so on and so forth.
That's right. That's correct.
So that's where we should be, isn't it?
That's where.
Thank you. That's really
In terms of
helpful to
reviews,
understand
yes.
the
I
map.
apologise again for the confusion.
So, forgive me, when in his judgment, Justice Ritchie places great emphasis on the fact that their 12 months is the cap, that only applies to that very first period, doesn't
Yes.
it?
Well, and to each subsequent period, as
I
it
got
were.
that,
on review.
yes. And that's what he meant, was it?
We assumed so. That's how we read it, my
Okay.
lady, yes.
Thank you.
And what I was going to go back to, just to finish off for now on the fresh evidence bundle, was page 16, where we have the Professional Conduct Committee's second review hearing, dated the 26th of July 2024. And as it's really page 21, I'd invite the court to look at, please. By that stage, the court will see there's various pieces of evidence which are put in terms of the reflections that have been undertaken and the work that's been done, and the conclusion, decision on current impairment, beginning at paragraph 25. We see it there. I'm not going to read it all out, but 28, the committee considered whether you had fully addressed the concerns raised by the previous committees with regard to your insight. It then goes on and addresses that, the testimonials and written reflections and so on, which Mr Aga was able to put forward. The committee found your reflective statement to be detailed, and it was clear that you had now understood the seriousness and the impact of your past behaviour on women. The committee also noted that you are remorseful and regretful of your past conduct towards person A. Testimonials from colleagues confirm that your attitudes and behaviour towards women have changed significantly. 29, you've engaged in the proceedings and addressed the requirements of the last PCC. I won't carry on, but the conclusion is you've now done that work and we're satisfied you're no longer impaired, and so we're going to remove the suspension. That's the background. That's all I wanted to say about the background. I'm sorry if it took rather longer than I'd initially indicated. Getting on to the main point of the argument, as I said, and I won't repeat it again, there are really three parts to it, but the first is the most important, and that's the simple question of construction. And so I was going to invite the court first, please, to look with me at the relevant provisions of the Act in the Authorities Bundle, tab 1, and then to look briefly at how those were interpreted by Mr Justice Ritchie in the judgment. We've put in several provisions, just as it were, to give a flavour of how the process works without suggesting that this court needs to spend any time looking at them. But the court will be well aware that the process essentially starts, it begins in section 27 itself, in part 3 of the Dentists Act 1984, tab 1, as I say, of the Authorities Bundle, with an allegation made to the General Dental Council of impairment of a registrant. Those allegations can be founded on a number of bases. Again, they're the familiar bases: misconduct, or deficient professional performance, or an adverse finding, or criminal conviction, and so on. There's then the role of the investigating committee, section 27A. I'm going through this very quickly because I don't think it's relevant, but it's just, and you know it so well, my lady, in particular, but perhaps it's, yes, tiresome even to hear it. But it then goes to the investigation committee, and the investigating committee can then decide whether or not to refer it to a practice committee. This was a case of alleged misconduct, so obviously it went to a professional conduct committee. And the crucial provision, we've referred to it already, to begin with, is section 27B, which is the powers of the practice committee. It's on page 12. The practice committee, subsection 4, is under a statutory duty. It must investigate an allegation or allegations against a registrant which have been referred to it by the investigating committee under section 27A. And its role is to determine whether that person's fitness to practice as a dentist is impaired. So that's the question: fitness to practice and the issue of impairment. I'm skipping over some of the other subsections until we get to subsection 6. If a practice committee determine that a person's fitness to practice as a dentist is impaired, they may, obviously they have a discretion as to sanction, if they consider it appropriate, direct, I'm sorry, I'm saying it in this slightly odd and forceful way, but the reason I'm placing emphasis on those things is to emphasise that it is a direction that's made under section 27B. It's not called an order. It's not an order.
But you will explain to us in due course what the difference between a direction and an order is. Because at the moment, although I readily accept that different words are used,
yes,
and they're different provisions,
yes,
is my provisional view,
yes,
I haven't been able to articulate for myself what is the difference between a direction and an order.
Can I deal with it now? It's
Whenever.
not defined in the Act, but a direction is a direction to the registrar of the relevant body, in this case the General Dental Council, to amend the register. So generally in Dentist Act or the Medical Act, Part 1 of the Act deals with the register. It deals with establishing, obviously, the General Dental Council or continuing the General Dental Council as well, but then imposes obligations on the registrar in relation to the register, and in particular, two elements of that: to maintain a register and to publish a register. And in relation to the register, the register. I'm sorry, these provisions aren't in your bundle, but we can bring the whole Act along if you'd like it. But the obligation of the registrar, as I say, is to maintain and publish the register, but also to respond and action, it doesn't say action, but to address matters raised by the council or a committee of the council. And a practice committee is a committee of the council, of the General Dental Council. And so a direction under section 27B is a direction to the registrar to do something to the register. That is to say, it changes the status of the registrant. Obviously, in a case of erasure. Sorry.
Exactly. No, that's the point I was going to come to, the erasure point, and that's why it's framed in that way.
Yes, exactly. Yes. And an immediate order is just an order that the person's registration is altered in status, either because it's subject to an immediate order or it's subject to an interim order. I don't know if that is satisfactory, my lord, as an explanation. No, well, I'm not entitled to ask your lordship, really.
But a direction under 27(6), and let's deal with 6B.
Yes.
They direct that his registration in the register will be suspended. What that means is the registrar becomes conscious of the direction and changes the register.
Yes.
With an order under section 30, the registrar becomes aware of the order and changes the register.
Well, it wouldn't be the registrar that does it formally, because it's not formally a change to the register. It appears on the website if you've got an immediate order or an interim order. I accept that, so to that extent. But the register formally is something distinct from the list of registered medical practitioners or list of registered dental practitioners that appears on the internet.
But under section 30, may order that his registration shall be suspended forthwith.
Forthwith, yes.
So you say that has effect even before the registrar has adjusted the register?
It doesn't have to, no, I'm sorry. If that is what I said, I apologise, my lord. That's not what I meant to say. It's not self-executing, but it doesn't require an act of the registrar to amend the register to give effect to an immediate order or an interim order.
Is the registrar really, the only thing I can see is erasure will require the register to be amended. That's the easy case, isn't it? Because the name is rubbed out, it is erased. But where you have a suspension, the person in question, the registrant, will remain on the register, but suspended.
That's correct.
Does it matter very much in terms of what sort of suspension you've got, interim, immediate or substantive? They're still on the register.
Perhaps not to the registrant, no, but it appears in a different way.
Yeah.
If you look up your treating physician or dentist, it's clear if they're under a matter which might turn out to be without foundation, if they're subject to an interim order, say, before a hearing, or an immediate order which might be overturned on appeal before the direction. But if the direction enters into force, that is the judgment, as it were, of the council that your fitness to practice is impaired. So that was the first point about the difference, about the test then. It's about impairment. And it also provides, and your lordship's already drawn attention to section 27B6B, the provision we're concerned with, that is to say about a direction for suspension. And it has within it its end point, doesn't it? Because it says not exceeding 12 months. And I know we've addressed that already. Subsection 8 makes clear the right of appeal. The court's well aware of that, was obviously exercised in this case. Of course, I'll be coming back to this, but that's what section 27B says in substance. 27C is about the reviews or resumed hearings, as they're called. Section 29, then, going down on page 17, headed Appeals, refers to appeals against a direction for suspension in 29(1)B. And I have an apology here to make, because I think in my skeleton it said section 29 brackets 1 large b close brackets. That was a typo and I apologise. I hope it didn't take the court. It was in footnote 4 of my supplementary skeleton. That's not correct. It should have been section 29 brackets 1 brackets lowercase b. But that's what I was referring to there. And then we come on in 29A to the provisions on taking effect, on page 19, taking effect of directions for erasure, suspension, conditional registration, and so on. It's clear that this is only about directions because we can see that it says so. This section applies to A, a direction of erasure, B, for our purposes, a direction for erasure, suspension, conditional registration or variation of or addition to the conditions of registration given by a practice committee under section 27B. And then 29A2, a direction to which this section applies shall take effect. So that language is, of course, mandatory, and it applies to all of the directions referred to above. That is to say, erasure, suspension, conditional registration or variation thereof. And it takes effect in one of those three cases. I wasn't going to read them all out because the court's no doubt read them already, but in section 29A, 2A, B or C. Where there's no appeal, it's after 28 days. That's A. Where an appeal is brought but withdrawn, it's when that takes place. But for our purposes, it's C, where such an appeal is brought and is not withdrawn or struck out for want of prosecution on the dismissal of the appeal. So applying the natural meaning, we say, of this provision read with section 27B, the direction for 9 months suspension that was imposed by the practice committee would have taken effect on the date at which Mr Aga's appeal was dismissed by Mr Justice Ritchie.
And take effect. I know it's always dangerous to paraphrase what's in the statute, but the impact that I think you submit is that take effect throughout this section must mean come into effect, and in that sense start.
Yes.
And in that, or commence, and in that context, the use of the word start or commence is clear, because before the 28 days, there is no suspension.
No.
And it has to have that effect. It has to have that meaning. The words shall take effect must have the same meaning whether or not an appeal is brought. Yes. And that's your point.
Say. That's my point, yeah.
Yeah. And for the avoidance of any doubt, the word start is not.
No, the start's not in there. No. Then section 30, which is about the orders for immediate suspension and immediate conditional registration. And again, I make the point, I've made it already, but these are orders, is the first point. But that's almost emphasised further by the fact that, for example, section 31 refers to what is the trigger for an immediate order, being one of the directions that we've just looked at under section 27B. In particular, I should say, a direction for erasure or suspension under 27B. So on giving such a direction, for suspension in our case, section 30 brackets 1, the practice committee giving the direction, if satisfied that to do so is necessary for the protection of the public or is otherwise in the public interest or is in the interest of that person, may order that his registration shall be suspended forthwith in accordance with this section. So I made the point about the difference in the language. There's also very clearly a different test. The test here is not, because it follows from a direction relating to the question of impairment. It's a different test about whether or not it's necessary for the protection of the public, otherwise in the public interest or in the interests of the registrant. So a different test as well as being different nomenclature, as it were, and only occurring after that previous stage of a direction, so the determination on impairment being made, determination on sanction, and making a direction. It then says, it also deals in section 30, in the provisions I've just read out, with when it starts, and my Lord Justice Stuart-Smith has already made this point, it shall be suspended forthwith in accordance with that section, so that if we're looking for the start date, I'm sorry to do those inverted commas, but just because it's not a term of art in the Act, if we are looking for the start date, then it's clear what the start date is in relation to
immediately effective.
It's immediately effective, yes, exactly. And in terms of what's the end date, well, that's what we're going to come on to. What's noticeable is that there's nothing in section 30 which says you can impose an immediate order for up to 12 months or up to 18 months. And then it has to come back and you can decide another one. There's no upper time limit. The end date is determined by section 33. And again, I won't read all of that out, but where on the giving of a direction, an order under subsections 1 or 2 is made in respect of a person, his registration in the register shall, subject to subsection 6, be suspended from the time when the order is made, that reinforcing the point in subsection 1, until the time when, and then A, the direction takes effect in accordance with section 29A. And then you've got the provisions about the appeal there. So we say that makes it crystal clear that these are consecutive periods, that an immediate order happens straight away and carries on until the direction takes effect. Got the language of the direction taking effect again in section 33A. That's determined. When the direction takes effect is determined by the provisions in section 29A we just looked at. And it's clear, therefore, it's a crude way of putting it, but it's clear, therefore, that under the Act, there's no scope, or if properly interpreted, we say, there's no scope for them to overlap. There's no scope for them to run concurrently.
Which is the point taken subsequently by Mr Justice Morris.
Indeed. So, my lady...
Just one tiny point, I think I know the answer to this. It all works through, in this, if the appeal succeeds against the substantive direction,
yes,
then the immediate order falls away.
Yes.
You don't need anything to tell you that because it just clicks through.
It does, exactly, yes. Thank you for that, lady. I was then going to go back to the learned judge's judgment below. I'm not proposing to take the court through it because I know the court's read it. But really the key points we say are paragraphs 36 to 43. So as I indicated, and the court has it, in the core bundle beginning on page 50, we have the judgment. There's a section beginning on page 64, beginning at paragraph 36, where the learned judge has a section under the heading grammatical meaning. I've put this section 36 to 43 as including 7 points on the part of Mr Justice Ritchie, some of which I have to say General Dental Counsel doesn't disagree with, but I wonder if I could just go through those quickly. The first in paragraph 36 is that there is no doubt that a direction under section 27B is limited to 12 months. We accept that, always have accepted that. That's the first point. The second point relates to the taking effect of the suspension direction. Mr Justice Ritchie begins, section 29A determines when the section 27B suspension direction usually takes effect. I'm afraid we don't understand the reference to usually there. We say it determines in all cases when it takes effect. But it's the bottom of that paragraph I wanted to invite the court to have a look at. The last 4 lines. What the section does not do is expressly state how it interacts with section 30 in relation to the duration of the suspension, nor does it set any start date, a term to which I will refer to below. Parliament could have made it clear how Section 29A would interact with Section 30 in relation to duration, but did not do so in this section. Well, we don't accept that for the reasons I've just explained. We say it's clear when you read 27B, 29A and 30 together, which we say is what you have to do, that each of those provisions identifies the start and the end date of the relevant direction in an appropriate case or order. So that's the second point. I'm afraid we don't accept that. The third point, under the heading immediate suspension, paragraph 38, so Section 30 creates a taking effect date for the suspension which is different from the default date. In my judgment, the plain grammatical meaning of the words in Section 30 is as follows. Subsection 1 makes it plain that the power granted to the PCC under Section 30 only arises on giving a direction for suspension. We accept that. Thus, the Section 30 power is parasitic on the Section 27B direction for a suspension. We accept that too. What we don't accept at the bottom of that page, still in the same paragraph, is where the learned judge says, although the section does not expressly say so, the immediacy of the taking effect, is clearly intended in the context of the previous three sections to cover the gap left by the default taking effective dates, all of which involve a gap. Sorry, I think we do accept that. I'm not quite sure if it means what I think it means, which is you construe Section 30 to ensure there's no gap in the period when a relevant registrant is suspended.
What does parasitic mean? I don't. In my language, it's not parasitic.
No.
It's just the power to make an immediate suspension order doesn't arise unless and until they've made a 27B order.
Yes. Well,
so that's not my idea of parasitic. I think what he simply means is what I've just articulated.
Yes. Well, that's how I understood it, and that's the sense in which we, I think, agreed with it. And it's really in the sentence before, isn't it, where the learned judge puts it in the way that your lordship has just put it. The power granted to the PCC under Section 30 only arises on giving a direction for suspension. So that's what we certainly agree with, but yes, whether that makes it parasitic or not. It's a condition precedent for the making of an immediate order that there should have been a direction under Section 27B.
Probably the best way of putting it.
Yeah.
That's the third point. The fourth point, in paragraph 39, about 5 lines down, beginning, nothing is said about thee. So here, the learned judge is talking about Section 30. Nothing is said about the suspension being of a different kind of suspension or being a different beast under Section 30, as distinct from the suspension made in the direction under Section 27B. We don't, of course, accept that. We say it's clear that they're different. One's a substantive suspension after a finding of impairment, the other an order intended simply to protect the public in the interim period before the substantive direction takes effect.
But not necessarily.
Sorry?
Not necessarily, because Section 30 has interest of the registrant.
Oh, sorry, yes. I was using that as a shorthand. I'm sorry, my lord, yes. Yes, you're quite right, yes. Yes. I mean, that normally arises in health cases where it's in the interest of the registrant to impose. Yes, I'm sorry, of course, your lordship's quite right. There are three bases.
It does go to one of Mr Justice Ritchie's points, which is that the grounds upon which, although it's a separate question, I accept that for the moment, the grounds upon which Section 30 says you can make an immediate suspension order would all be material when making a 27B. Could all be material.
Yes.
So
Yes.
there's no, you don't have a point which says the grounds for making a Section 30 order are different, and therefore it's a different, to use Ritchie term, Mr Justice Ritchie's term, beast.
No. There plainly can be overlaps between them, yes. The test...
Between the considerations.
Yes, the test is different. One is really looking at the registrant. Are they impaired? That's the trigger for the direction. And then what's the length of and what sort of suspension or whether it's erasure is determined by public interest concerns and so on. Reputation of the profession and all of those considerations. It's clearly a public interest. Are you protecting the public or other aspects of the public interest or the registrant themselves in relation to Section 30? But it's really what Mr. Justice goes on to say after that passage that I wanted to highlight. And that is where he says, they're just under the passage I quoted, the use of the word order instead of direction needs some thought. But unless I've missed it, the judge doesn't then return to analyse if there is actually a difference between direction and order. And we agree with that. We agree that it needs some thought, and I've tried to address what we say it means when you think about it. But we don't find that, my learned friend will correct me if it is addressed later on, but we don't find that in subsequent parts of the judgment. That's the fourth point. The fifth point is paragraph 41, where the learned judge says, I note that nothing is said in section 30 about empowering the PCC to make the immediate suspension order as a cumulative suspension or a different suspension in addition to the direction for suspension. Nor would this be the ordinary understanding of the section. So that, I mean, perhaps, I won't read it all out, but perhaps the court could just sideline that paragraph. I'm afraid we don't accept any of the assertions made there by the learned judge with respect about that. And that's the fifth point I wanted to draw to the court's attention. That brings us to the last 2 points. Paragraph 42 over the page on page 66. The judge there makes this point, and it's been referred to by my Lady Justice Nicola Davies at the top of the page. So once the appeal is dismissed, the PCC's original direction for suspension takes effect. The word used is not starts, nor does any section say that the suspension starts then. This is the root of the grammatical analysis of the interaction between the sections. It has led to confusion because takes effect has been interpreted as start for the purposes of determining the duration of the directed suspension after the end of an appeal. And we say that's right. It has been interpreted that way, and that is the correct interpretation of takes effect. That is what it means, is that it starts or commences once the appeal has been determined. And the final point in this section, 43, is where the learned judge says this: from this analysis I conclude that the sections do not deal expressly with the issue of whether the period of suspension served under an immediate order is to be deducted from the period of suspension served under a direction, or whether one follows the other in full. Thus I shall look at the legal and factual context and the purpose of the sections and the consequences of various proposed interpretations for assistance. And then the learned judge has a lengthy section where he goes through the relevant authorities. I wasn't proposing to go through those.
Pausing on paragraph 43, your seventh point.
Sorry, yes.
You don't agree with that because you say that the legislation is clear, don't you? That the sections do deal, in effect, if you read them properly, with the issue of cumulative,
yes,
concurrent,
yes,
consecutive. It's all built in.
They don't use the word, this is to run concurrently, that's correct. But when you look at what they say about when it starts or takes effect and when it ends, that must be the intention.
Is perfectly clear, you say.
That's what we say. Thank you, Milady. Then, as I say, the authorities, I'll come back, as I said, I'm not going to go through the authorities, but as I indicated previously, I did just have a couple of points, general points, I wanted to make about them. But just concluding on the judge's reasoning, we then get to page 85, very close to the end of the judgment, beginning at paragraph 90, under the heading, the proper interpretation of the Dentists Act 1984. And the heading there, just interpretation, taking into account the consequences. So that's the heading that the judge has put on this section. And he then makes essentially 5 points. He refers back to the interpretation section that we went through a moment ago. He refers to the purpose of the Dentists Act to regulate the profession. The objectives are set out in section 1 of the Dentists Act, the threefold purposes. Of course, we accept that. The Act creates a structure for regulation which involves education, training, and so on. We accept all of that. Then 92, the second point, the learned judge says the problem which has been identified is the effect of an immediate suspension order when an appeal is dismissed. And then he sets out the GDC's interpretation. And what he says about that is if the GDC is right, what that means is that in a case like this one, where Mr Aga has waited 4.5 months on an immediate suspension order for his appeal to be determined. If his direction for suspension in the substantive order then takes effect after the appeal is dismissed, he will have served a total of 13.5 months of suspension, and that violates the upper limit of 12 months, which is contained in section 27B. And he concludes there at the bottom of that paragraph, I consider that the GDC's interpretation of the sections drives a coach and horses through the statutory 12-month maximum on the PCC's power to impose suspensions, which cannot have been the intention of Parliament.
Mr Hare, I know I've raised this point before, but I grappled with this paragraph because I wasn't sure really what the judge was referring to when he referred to the statutory 12-month maximum.
Right.
I mean, it could be, as you are putting it, it is what has been termed the substantive direction, the substantive suspension, i.e. the first one. Mm. It is also clear that the power of review allows for further periods of suspension.
Yes.
And I just didn't understand whether the judge was referring to a general 12-month ban, statutory ban on in excess of 12 months or not.
Yes. Well, there is no such ultimate, as it were, limit of 12 months in total in the Act, and we had read it as a reference to the 12-month limit in section 27B on the direction. So that was the second point. The third point in this section, paragraph 93, I consider the GDC's interpretation of the sections is unfair to the appellant. The learned judge goes on, it effectively increases the PCC's carefully measured and titrated analysis just because he's appealed. And the learned judge goes on to say, I don't see how that. I don't consider that professional conduct and standards are maintained by such an approach. The judge concludes, I consider this interpretation, that is to say the GDC's, is contrary to one of the main objectives of the Act. Further, it's contrary to natural justice to penalise an appellant just for the act of appealing, not the substance of the appeal, when the right to appeal is provided by statute. So that's the third point. The fourth, 94, taking into account the wording of the section, purpose of the Act, context and objectives, the consequences of the various possible constructions and the case law, in my judgment, there is a difference between the words take effect and start. In the sections, the legislators use the word takes effect so as to distinguish between the ending of the effect of the immediate order for suspension and the commencement of the effect of the direction for suspension. However, there was only one suspension and it only started once. And in a sense, that's the crux of, that we say, of the judge's conclusion. And that's repeated in the only other point I was going to take the court to, and I'm not going to read it out, 96 to 97, the judge there makes the same point, that it's one suspension and it only started once. And the judge says, perhaps in fairness, I should just read part of 97. The correct construction of the sections, the judge says, is that start of the suspension was when it actually started, namely when the immediate suspension took effect. 2, when the immediate suspension order ceases to have any effect, then the direction for suspension will take effect. The changeover from the order having the effect to suspend to the direction having the effect to suspend makes no difference to the suspension. It remains exactly the same. In my judgment, the end of the suspension occurs after 9 months of suspension have been served, and it does not matter which piece of paper had the effect of causing the suspension. So that's the judgment leading to the order which I've shown the court already. I've been through what we say is the natural construction of the provisions, and we say it is inconsistent with what the judge has said. We say it leads to the conclusion, the only conclusion we say on the plain language, that the direction is to run concurrently after the conclusion of the immediate order. Sorry, my lord.
Consecutive.
No.
Sorry, did I say concurrently?
You
did.
I do apologise. I'm sorry.
And,
It makes quite an important difference.
The first time you said it, I woke up. The second time you said it, I thought I'd better say something.
You better say so. Well, I'm very pleased that you did, my lord, and I apologise. Consecutively, yes. That's it, we say. I've then got a series of points in the skeleton about what effect it would have if you applied the learned judge's reasoning across the board, which you have to do. A direction for erasure is also a direction under section 27B. It can't possibly be that an immediate order for suspension and an erasure are somehow part of the same sanction. It simply doesn't make sense. Only here in relation to suspension that it's even plausible to say that there's only one suspension. And there is authority, it's an obiter, but it is in the Supreme Court by Lord Wilson in the Khan versus General Pharmaceutical Council, and it's referred to by Mr Justice Morris in the Daniel case, where Lord Wilson is very clear that the period that had been spent in that case, subject to an immediate order, did not count towards the 5 years before an erased physician could apply to come back on the Pharmaceutical Council register, as it was in that case. So we say that supports our position. But, my lady, I've set all those points out in some detail in my skeleton. I don't want to go through them all. The only other point I was going to make about the authorities, if I may, is this. I've said already, we invite the court to be a little bit cautious, particularly in relation to the NMC cases, because of the different use of language there, where immediate orders and interim orders are both called interim orders and are derived from the same article of the relevant provisions. That's the first point. The second point is we accept, of course, that a number of judges have expressed concerns about the operation of the current provisions or disquiet about it. And sometimes they've remitted a matter and invited the reviewing panel on remittal to have regard to a period that had already been spent subject to an immediate order of suspension. But it's also clear that a number of the judges say, and we have it in Mr Justice Bean is very clear, there's nothing that he can do about it, he says, on the reading of the Act.
He doesn't actually decide that that is the meaning. He says, he expresses concern that if it is the meaning,
yes,
then it's for Parliament to change.
He does, indeed. That was the only point I was going to make about that. Yes.
Okay.
Thank you, my lord. Yes. And I set out also in my skeleton a number of anomalies to which it would have led. That's in the Ghosh case, isn't it, my lord? Yes, in tab 6, paragraph 27. And it's put, we say, by Lord, very well, if I may say so, by Lord Tyree in the W versus HCPC case. Again, I'm not inviting the court to turn to it, but it's tab 11 of the authorities, paragraph 38, where he says it's not for the court to innovate on the statutory scheme in this regard, that is to say, to change the effect of the interrelation in the Act between immediate orders and directions. That leads on to the concluding points. Again, I hope they're sufficiently addressed. The first one is in relation to the purpose, or one of the principal purposes of fitness to practice sanctions, to permit a registrant to undertake and to have an incentive to undertake proper remediation of the matters which gave rise to the impairment of their fitness to practice in the first place. If it's perfectly possible on Mr Justice Ritchie's interpretation that an immediate order could be in force for longer than a year, there's no upper limit, as we've seen, to the immediate order pending the determination of an appeal, if you appeal. And in that time, a doctor may well decide, a doctor or a dentist or another registrant may well decide they're not going to undertake any kind of remediation because they don't accept they've done anything wrong. If Mr Justice Ritchie is right, and it's taken more than a year, then there's no further suspension, and they just have to come back on the register in principle. I mean, presumably no court would order that, and the court would say there must be a speedy review of the matter. But
surely it would be interpreted that if that interpretation is right, it would be the 12 months reached as it happens by the immediate suspension is still subject to review, so that you couldn't possibly interpret it as meaning that you get rid of the prospect of review.
Well, an immediate order doesn't carry with it a power of review. That's only in a direction for suspension. It's only the substantive suspension that you would impose an order for review, because it doesn't arise in relation to the immediate order because the review will be in the substantive direction, which won't take effect until after the immediate order's over. I'm just saying, I'm not saying that's what Mr. Justice Ritchie was saying. I'm just saying there's a potential for it to be the case. Some appeals do take more than a year. If you look at the Daniels case that you have in the bundle, the Mr. Justice Morris case, took more than 2 years, I think, for the appeal to be decided.
So on the Ritchie analysis, you get to 12 months, and suspension then falls away because you've done as much as you're allowed to do on the combination of immediate and substantive. There is then nothing to review, so you can't have the substantive review process because that's all fallen away.
Yes.
So actually, it's in the registrant's interests. Well, the best thing for a registrant is to lodge an appeal and hope that it goes very slowly.
Well, possibly, yes, I suppose.
Whatever
To run
the
down the clock.
But that would apply, and that would apply whatever the length of what you've called the substantive.
Yes.
So if you've got a 6 month, string it out for 6 months. If you've got 12 months, you've got to string it out for 12 months to achieve this notional result, which I'm not prepared to accept.
Yes. I mean, I'm not here to defend Mr. Justice Ritchie. He might say,
No.
if it came to court in an appeal after that, then it may be that the direction should be given a short period of effect in order that the review process can take place. I don't know, but his judgment potentially gives rise to this difficulty. And as we've seen, and that's why I took the court to it when I was going through the relevant background, sometimes developing insight, remediation and producing evidence of it takes time, particularly if, as it was found to be in this case by the Professional Conduct Committee, it's an attitudinal issue. Your view of women, your view of junior members of your team, and so on. And as we saw, Mr. Aga wasn't ready when he first came before the resumed hearing of the fitness to practice of the Professional Conduct Committee. That's that. As regards fairness, well, I've made a number of points about this. Fairness is not where you start. In any event, the registrant knows that this will be effective there. This will be the effect of an unmeritorious appeal or an unsuccessful appeal. And as I've indicated in the fresh evidence bundle, the GDC has been consulting on whether or not its guidance for practice committees should be amended in order to deal expressly with this point. And it's at the very end of my skeleton argument, and it's in the fresh evidence bundle behind tabs 4 and 5. So the GDC launched a consultation in September of 2024. So at page 23, the court will see the GDC consultation document, consultation on revisions to the guidance and conditions bank for practice committees. It's dated there the 3rd of September 2024. And it sets out then in the overview, the overview section is mostly about the GDC. Then on 26th, the consultation period and deadline for responses. That consultation closed on the 26th of November 2024, as the court sees from page 26. My instructions are the GDC is going, there were a substantial number of responses, and the GDC is analysing those responses. So I can't say that it's imminent that there'll be a change to the rules, but to the guidance, I should say. But it was proposed that there should be a new provision in the guidance. Sorry, while looking at that document, could I just ask the court to turn to page 32 before I move on? So there's a section here under the heading Practice Committee Hearings, the determination of the case. And there's a reference there to new individual points of guidance, and new subsections in this section include, and then a series of bullet points, and I think the 6th of those says some aspects of the subsection on types of sanction, which in total runs from paragraphs X to X, and we're looking at orders, so yes, necessary term of suspension considerations. Paragraph 253, 254, which address the effect interim orders can have on the proportionality of substantive suspension orders. And then at the bottom of those bullet points, it refers to the judgment in Aga versus General Dental Council. So that was specifically in the mind of those who were carrying out the consultation. But the key point really is what is in the proposed amended guidance. That begins at page 38, but it's page 87 that has the relevant part for our purposes. Just gone past it. Paragraph 302. It's probably there. Apologising for being slow. Following an appeal, 302, yes, on page 87. I'll just invite the court to read that.
I can understand that where it talks about the appeal being unsuccessful. So I think the idea is that if you're still then left with the same period of substantive suspension, you can at least come back to the PCC to say, look, I have already in fact done 9 months waiting for my appeal, so could we have a conversation about what would now be proportionate?
Yes.
Got that. What about, and I can understand at the other end of the extreme, if you have an appellant who is wholly successful and their 9 months is eradicated completely, then it all falls away and they walk free and they're not suspended anymore. What about the more likely situation where you have somebody in the middle who succeeds to an extent? So let's say the original imposition, substantive imposition, was going to be 9 months. And let's say they have a semi-success and the 9 months is reduced down to 6 months as the proportionate sanction.
Yes.
That person, that's the person for whom it's really unfair because they are worse off because they took an appeal that ended up being successful. Because if they've waited 6 or 9 months for their appeal to come on, they end up doing more rather than less.
Yes.
But is that person... I've been thinking about how you sort that person out, and in the end, there's no perfect answer to it.
No.
But I think all you can say to them is, well, you really do need to get your review hearing on as quick as possible in front of the PCC, and you need to make those points to the PCC, and they should take them into account.
Yes, and I wonder if that could be addressed somehow in the language of the appeal being successful, whether it could be if the appeal is other than wholly successful, which might cover...
So can you take this as a consultation
Well,
gathered from me? Yeah.
The consultation is closed, my lady.
Well,
I'm
I
very sorry.
know, but I've still got the right people there.
I'm sure
But that does trouble me, because
Yes.
that's the real unfairness, is that
Yes.
you can end up being worse off bringing a
I see
successful
that.
appeal.
Yes. Thank you, my lady. Well, I'm sure that has been taken note of. My lady, they were my submissions. Thank you very much.
Thank you, Mr. Hare.
No, thank you.
Thank you very much indeed, Mr. Kennedy.
My ladies, my lord, can I start just with this? As I acknowledged in the course of my learned friend Mr. Hare's argument, this was not a point I took below.
And when I said...
And?
Sorry.
And? Are you defending it?
Well, it's a serious point, and I just want to come on to deal with that, because I have to make another, effectively, confession, if I can. The reality, of course, is now that by virtue of the order in July of last year, Mr. Aga is now back on the register. And so, from his personal perspective, this is fascinating, but it doesn't affect him anymore. So I have to acknowledge both those points.
So where does that leave the court and you
Well,
as his representative?
that's my learned Lord Justice Stuart-Smith's point, which is, and the answer that I can offer is this, that it's a matter which is of concern to the profession, or to the professions. And it's not just the professions, because it's been of concern to the courts as well. And so it's important that this court grapples with it if it can. And if there is some clarity at the end of the exercise, that clearly would be desirable.
Well, the position at the moment is that there are now 2 conflicting High Court decisions, aren't there?
Yes.
I mean, that they are there's a fundamental disagreement between the judgment of Mr Justice Ritchie and the judgment of Mr Justice Morris.
Indeed.
And so in those circumstances, assistance from this court would help.
Clarity, indeed. Any clarity. It was desirable, perhaps, before the conflicting before the decision in Daniel, but it's more so now. I hope I'll be forgiven for if I start with a bit of a jury speech.
Near
The reality is, on any account, that the standard practice that is adopted by the GDC produces results which are unsatisfactory and unfair. And they're unfair in the sense that, first, the consequence of an unsuccessful appeal can be for the registrant a period of suspension that was longer than that was directed by the, in this case, the Professional Conduct Committee, and longer than the statutory maximum. And for these purposes, the statutory maximum is the Section 27B 6B statutory maximum of 12 months. Second, it has therefore the tendency to discourage, or at least caution, a registrant in exercising what is an unqualified right of appeal. And the added difficulty, so my third point is that even if the registrant doesn't exercise his statutory right of appeal, the effect of the standard practice is to increase the total period of suspension by 28 days. Because he starts on day 0 and finishes 12 months and 28 days later, if he's given a 12-month period of suspension.
And if he is subject to an immediate order.
And if he's subject to
which he may or may not be.
Which he may or may not be. But my point is, it bites on the registrant.
Yeah.
When as soon as the immediate order is imposed, irrespective of whether he exercises his right of appeal. It's just that the unfairness, if I can give it that label, is potentially greater for the registrant who appeals than the one who doesn't.
Well, who appeals and loses. Who appeals and loses.
Who appeals and loses, yes.
Who mistakenly brings an appeal which is not successful.
Indeed.
But if he appeals and wins, the whole predicate of this, isn't it, is that he's been subject, he, she, whoever, has been subject to an immediate order. So the appellant who appeals and wins actually might be in a really bad position. They have been suspended pending the appeal, and they get nothing for it. They might have been suspended for some months.
Indeed. So
with a complete appeal, with a complete success.
So, I mean, the answer to any of those may be, well, you have to exercise your right to seek termination of the appeal. Sorry, termination of the immediate order.
Could you, because I don't think we've been taken, could you take us to the provisions for early review or whatever it is? Because there's something, it's either in statute or it's in the guidance, which enables a person, other than by statutory appeal, to ask, am I completely wrong about this, to ask the GDC to bring forward a date of review?
Can I deal firstly with termination and then come to my Lord Justice Stuart-Smith's point? So termination is section 30, subsection 7, on page 21 of the authorities bundle. And that...
Sorry, I lost the page number.
21.
Thanks very much.
So the application is to the court, which is what you did in this case.
Yes.
That sounded like a qualified yes.
It was qualified only to this extent, that I included the application for termination within my appellant's notice as an additional application. I think it would be possible to do it freestanding.
That's the way I read it, I must say. I can't say I have any experience of it, but that's just the way I read it.
My experience is relatively limited, and that's the route that I have used in the past and you have used in this case. But when preparing this, I came across a decision in a case which I was involved in, which I completely forgotten about, where a master dealt with an application to terminate. But what I can't tell you is whether that was because the application was issued separate from the notice of appeal or within the notice of appeal and was simply heard by the master. I'm not aware, but I'll be corrected if I'm wrong, I'm not aware of any other mechanism by which an immediate order can be influenced or affected. So the only answer to the unfairness is the application to terminate. And as Mr. Justice Kerr said in Hill, that may be, I'm very much paraphrasing, that may be illusory in the sense because of the delays getting cases on.
Well, one could always ask for an expedited hearing.
Indeed, indeed. So, for any of those reasons, there is at least the potential for unfairness. The High Court has expressed those concerns in a number of cases. It's perhaps just worth bookending or the reference to Khan, and it may be helpful to turn Khan up. So it's in the authorities bundle.
That's 9, tab 9.
Tab 9. Thank you. So page 139. And the passage that my learned friend set out in his argument was at 145, paragraph 22. So Mr. Khan was erased from the register. So he was a pharmacist. And in the second line, the committee exercised its powers under Article 62, subsection 2, to direct that Mr. Khan's entry on the register be suspended forthwith, pending the coming into force of the direction. And then direction for removal has been under appeal ever since. And then the term interim suspension is used again, but it has the meaning of immediate in GDC language. So Mr Khan's interim suspension has continued ever since. In other words, for almost 3.5 years. So he was in a worse off state than Mr Daniel. And then they make the observation, which my learned friend relies on, the period of interim suspension would not count towards the period of 5 years after which Mr Khan could apply for restoration to the register, because the matter would begin only on the date of the removal. But just, as I say, to bookend that, if I may, and just go on to paragraph 40 on page 149. What effectively is the substance of the disposal. So the committee, so that's the pharmacist committee, itself acknowledged that its direction for removal might appear harsh. It was indeed harsh, it was unnecessary, it was disproportionate. The sanction proportionate to the disrepute into which Mr Khan's conduct had brought was likely to bring the profession of pharmacy was suspension of his registration, which at the time of the committee's determination should no doubt have been for a period of a year. In other words, the maximum, statutory maximum. If you go over the page to the conclusion, in the conclusion on paragraph 41, but over the page, the direction that is actually made is, I think we read at D, instead of the committee's direction for his removal from the register, so in other words, erasure, direction for his suspension from it should be substituted. And then this, in light of the length of the interim suspension since the date of the committee's direction, the period of suspension should be 4 months. And so it's not a set-off as such, but it's something that is taken into account. And for what it's worth, that is accompanied by a review.
So this would have created a suspension of 4 months from the date of handing down of this judgment.
Yes.
With
As
a
I
provision for a
understand it,
review. Yep.
Indeed.
Sorry to be so slow.
The reality is, as my learned friend's taken you to, the GDC itself recognises perhaps I don't use my initial expression of unsatisfactory, but certainly the unfairness of the situation because of the way they frame the consultation. And so my learned friend took you to paragraph 302 on page 87 of the fresh evidence bundle. So that recognises that at the conclusion of an appeal, it may be appropriate to review the direction, bearing in mind the length of time that the practitioner has been subject to an immediate order.
Well, there's nothing in the statutory setup at the moment that prevents them from doing that, is there?
There's nothing in the statutory setup.
No, but it goes back to what I think I raised with Mr. Hare very early on, that on a review, it could be material that during a period of an interim suspension, or an immediate suspension, the registrant has made good or less good use of his time.
Yes.
In fact, that's the central approach, as I understand it, of these review meetings. Having given an indication initially of what they expect to see, they then review and see what progress the person's made during the period from the date of the original determination, which includes the whole of the immediate suspension.
Precisely.
So there's nothing to prevent them doing that. I thought you were suggesting that there was an unfairness because the review process wouldn't take into account the fact of the immediate suspension.
I'm
Is
sorry,
that what you were saying?
No, I'm
My
cross
mistake.
purposes. I do apologise.
My mistake.
I think it's probably mine, but no, I'd understood the question to be: is there any way of influencing the immediate order? To which the answer is only by way of application to terminate.
Okay.
But in terms of review, there's nothing in the statutory scheme that talks about review at all, talks about a power to have a review. It talks about what you should do if you have a review, which it calls a resumed hearing. But it doesn't actually say that you have the power to order a review, nor indeed do the rules.
I'm sorry, the fault is mine. When you say there's nothing there that talks about a power of review or order of review.
It was loose language on my part. I meant to say there's nothing in the statute or in the rules that confers a power to direct a review.
On whom?
On a practice committee, professional conduct committee for these purposes.
But they obviously do have power to direct a review, don't they?
The practice, well, sorry, perhaps point one is by inference, yes, because the Act talks about what you should do on a resumed hearing.
Mm-hmm. Yeah.
But what there isn't is between section 27B, which is the first hearing, and section 27C, which is the resumed hearing. There's not a provision saying you may or should direct a review. That
so
comes
from
out.
the PCC's point of view, it's an implicit discretion.
It's an implicit.
Isn't the point we're really on, though, more to do with the registrant demanding a review because they think something very bad is about to happen? They're going to be treated unfairly.
That is the point we're on. Yes.
Yeah.
I'm sorry if I'm taking.
There's
some
nothing
time.
in the statute to give a right to ask for a review or to accelerate it or do anything about it.
No, there's nothing either way. Whether for the registrant or for the council in these circumstances.
So the registrant's only recourse is the application to the court to terminate. It can't do anything else.
In advance of the appeal.
Well, it doesn't have to be in advance of the appeal. Well,
The only recourse to the immediate order, the only recourse to the imposition of the immediate order is an application to terminate.
yeah.
And the only recourse for a registrant, once you're into, let's say, the appeal has happened and has not been wholly successful, so you've still got a period of substantive suspension to serve, your only recourse then is to ask the PCC nicely if they would let you have an early review, and hope they will.
Indeed. And take your chance.
And so the granting of that earlier review would be at the discretion of the GDC. Is that correct?
That could be the only understanding, I think.
With a judicial review of the GDC, if they don't give you the review that you think you ought to have.
So potentially, yes.
Can I just see if I may be missing the point, so can I just see if what I've written down is okay? On hearing an appeal against the direction, the section 27B direction, use of time during the immediate suspension may be and often is relevant. And that's because once you've appealed, it's the immediate order for suspension that is keeping you suspended. Up to the date of the appeal, you'll be if you appeal, you'll be suspended by the immediate order for suspension.
Correct.
but the review will consider the general question whether fitness to practice is impaired, even if that was not the reason for the imposition of the immediate suspension.
Correct, but I'm afraid I'm not sure I agree with the first proposition.
The first bit.
And it may just be because of the use of the word appeal.
Challenge. Yeah.
Well, it would have to be review. Because if you're talking about an appeal, what the registrant has done between the imposition of the sanction and the appeal is unlikely to be relevant to whether the decision in the first place was correct.
I may be getting confused. There are two things. First of all, there's the ability to appeal or to challenge a direction. Then there's also a review which happens in due course in any event, if it's been ordered.
Correct.
What my first point was, if you appeal the direction, which I think is 29(1)(b), if you appeal against the direction, which is what this registrant did to Mr. Justice Ritchie, the effect of the provisions we've been looking at is that until the hearing of the appeal, you will remain suspended by the immediate suspension order.
Correct.
Yeah, okay. But even if you appeal, even if you come before the court on an appeal against the direction, your use of your time during the immediate suspension, which has kept you suspended, will be relevant to the determination of that appeal.
Only to the extent I can see.
Okay,
only
I see the point.
That sanction would become at large again,
I see
As
the point.
they did in Khan.
as they did in Khan.
Yeah. Okay. So I think where I was going wrong is that on an appeal, what's being looked at is the correctness of the direction when made.
Exactly.
Precisely.
And you're right to pull me up on that. Okay, I understand. Thank you.
I was just going to make one further point. It may be simply to add to the list of late consultees, but in paragraph 302, there is a requirement that the PCC has directed a review. So and this was the point I was rather laboriously getting to. The registrant who's immediately suspended, but a review is not ordered, gets no comfort from this mechanism.
But then aren't we then back into the discretionary territory? It's always open to a registrant to ask for a review, isn't it? Or not? Does it have to be part of the order before you can start saying, can I have it earlier rather than later?
The short answer is I don't know the answer to that. It's I don't know what the council's practice is.
Thank you.
But I would have to accept that theoretically, at least, a registrant could say, can I have a review? And if this guidance was to be in force, a registrant could say, because of the way you've worded the guidance, I fall between two stools, and it would be fair to give me a review. Yeah. The other point that the council were consulting on, I think my learned friend took you to it, was...
Pause. Let's do some more consultation, shall we? 3021, would you then say that the point they make is that where the PC has imposed an immediate order on the registrant, that's all you need to say, and the registrant appeals the sanction, the registrant's unsuccessful, the registrant should then be able to request that the PC convene a resumed hearing to review the substantive sanction. Shouldn't depend on whether there's a direction for a review or not.
No, it shouldn't. Sorry, that was my late consultation, would be to strike those.
Good, yes,
those
well,
words.
I understand that, and I just wanted to push that point home, and I think we've probably more than done that. Thanks.
I was just going to, while we were on consultation, was just really, I suppose, to identify the anomaly that comes out of one of the other points on which the council consults, which is what account to take, if any, of an interim order. And this is page 79 of the same document, paragraph 253, where it's considering conferring...
Sorry, page 253
Sorry,
of...
para 253,
Right.
page 79, same bundle. Where it's consulting on conferring a discretion on a practice committee, PC practice committee, to have regard to an interim order.
Yes, you can do that. I mean, the analogy that was used in the skeleton arguments was time spent in custody in criminal proceedings. The whole point about an interim order is you know what you're dealing with, you know the time.
Indeed.
Yes. So there is... Mr Kennedy, I'm sure the fault is mine. I don't know at the moment what your final position is on the judgment of Mr Justice Ritchie. And therefore the point I was seeking to make actually depends on where you are on the judgment of Mr Justice Ritchie.
It was a humane attempt to resolve the problems that have been identified.
Yes,
and
I understand what you're saying. Are you actually defending the judgment?
I say it would be open to the court to say it wasn't wrong.
Is that as far as you're going?
That's as far as I think I need to go, that you can say that he wasn't wrong.
But that, you can only say that if you reject the construction argument that Mr Hare has put forward, which is essentially what Mr Justice Morris said.
Indeed.
So
you'd have to accept the...
If you're going to say, I don't want to be unkind, but if you're going to say we can say that the judge was not wrong, you're going to have to help us a little bit about why he was arguably not wrong in the face of that construction argument.
Indeed. Can I come to that, if I may, and come to the points that my learned friend makes?
But I haven't quite got your point on para 253 yet. Is it that if you're going to take regard of interim orders, accepting what my lady says, you should at least make it possible for the PCC to take into account the duration of any immediate order if this comes back to them after an appeal, say?
A, that, and B, in any event. It's an anomalous situation where you...
That's the Ritchie point. You should take into account if you're going to give them a dollop of...
If you treat it as one suspension, then you take it into account, and that would be consistent with taking into account a period that you know has been spent suspended before the substantive direction.
And that was a point made by Ritchie, wasn't it? That he thought you should at the very least take into account what you're likely to do in the meanwhile.
That was his criticism of the way that the PCC in this case acted. But he as my lady said, his point is there is a single period of suspension, and therefore it automatically takes into account any period spent immediately suspended, because it's just simply from his perspective, when does the clock start ticking? And what I think he would say is, whenever it starts ticking, it's got to stop ticking after 12 months. Or whichever shorter period the substantive direction was. So if the substantive direction is 6 months, it must stop clerking after 6 months. There's then a review, so be it.
So there are two possible consequences. One would be to say that imposing an immediate suspension, let's assume the simplest case where there's no appeal. One would be to say the imposition of a immediate suspension was unlawful if you were directing a 12 months suspension under Section 27B, because the combined effect would be to make it 13 and a half months, or 13 months, plus review, either plus or without review, it doesn't matter. If it's unlawful, we're in open territory, or possibly in JR territory, but we would need to consider the consequences. The alternative is to say, which is slightly more moderate, is to say that if that happens, you have to give credit for the period of 28 days when you are suspended. So if by some magical means the suspension, the review date has to be within 12 months less 28 days, or it must be within 12 months of the date of the order being made.
Indeed.
That's the simplest case. That's the case where there's no appeal. But I think it would work through in the same way if there was an appeal, subject to the suggestion by Mr. Hare that you could get to a situation where you demolish the right of review, or you just bypass review. It's very
well, the answer to that latter point may be Lady Justice Whipple's point, which is that there's always a discretion to have a review.
Discretion on GGC.
Indeed.
So if they've got a person who has appealed, the appeal's not coming on, they're coming up against the arguable 12-month statutory maximum. They just have to say, right, we're going to have a review after 11 months of the period that would have been from 28 days.
Yes, within on that analysis, 12 months of the making of the order.
Yep. What a mess. You don't have to say anything about it.
No. It's I accept entirely. It's not. There's not an immediately straightforward answer. Balancing the competing fairness and unfairness. And perhaps I should just say this as well, that I don't have, I'm afraid, a satisfactory answer to the point that my learned friend makes about immediate suspension and erasure. That is equally problematic. Of course, that was the original mischief of the whole immediate order scheme, and that was the reason for putting the the Hansard material before you. It's the doctor who is erased, who can then either practice for 28 days as of right, or put in an appeal as of right, who in either case, who in the latter case then can carry on practicing until the end of his appeal. That was the mischief that the immediate order was introduced to address. But it's had, we would suggest, an unsatisfactory and unfair consequence because it's been extended to the power, extended where the substantive order is one of suspension.
On a more modest point, do you know why you have the 28 days as a sort of a period before the substantive comes into effect?
It's simply the appeal period.
I know.
Sorry.
It's the appeal period. But most things where you make an order for something, you don't suspend it pending. You don't relieve from the sanction while you're conducting your appeal. You just get on. It happens from the moment the sanction is announced. You are suspended. If you choose to appeal, you can appeal, and we'll see where we get to. I mean,
I'm sorry, I don't know the answer. Save that for as long as I've known, that's
always been the way.
It's always been the way.
And I confess I can go back a few years more than that, and it's always been 28 days.
Mm.
All right, Mr. Kennedy, where are we going now?
Can I deal with the construction and particularly the points that my learned friend relies upon in terms of the difference between one and the other? And so this is his paragraph 17. If I may just deal with what perhaps the more straightforward responses first. So the ones which are more readily dealt with, seems to us, are 4 and 5. That the judge was wrong because and wrong to say that there was one continuous suspension, because they're in fact distinct, because they apply a different test and serve different purposes. I've set out our response in my skeleton. This is paragraph 7D and E, and in fact I've conflated D and E. But the short point is that, or the short points are that, firstly, the test is one of necessity in both cases. So it's necessity in section 30, subsection 1, necessary for the protection of the public or otherwise in the public interest. I'm not going to read on the interests of the registrant. I don't agree with my learned friend when he says the test for the substantive sanction is different, because the test in section 27B is whether the practitioner is impaired. Because impairment is a gateway to the imposition of sanction. There has to be a reason to impose a sanction. And as I've indicated the guidance in 7D. The guidance talks about any sanction and the period for which it is imposed must be necessary to protect the public interest. So in either case, the test is effectively one of necessity. The purpose is, in our submission, identical, because however you dress it up, the purpose is protection of the public interest. So the Section 30 uses the expression protection of the public or otherwise in the public interest. The guidance for the imposition of sanction talks about protecting the public interest, and then when one then goes to I can take you to this, paragraphs 511 if necessary, for the definition of the public interest. So the test and the purpose are the same. The fact that going to his point 1, the fact that the direction and the order are made under different sections of the Act seems to us to take it no further. It serves simply just to identify that the two do not necessarily need to be exercised together. The use of the expression direction on the one hand and order on the other hand it is correct that is how the statutory language speaks, but it doesn't make the suspension different in any ways different. It's felt in exactly the same way by the registrant, whether it is immediate or substantive. And whilst with the help of the line being drawn in the direction, one can say, in the decision we looked at earlier with my learned friend, under I think paragraph 91, whatever it was. Technically, they are separate decisions. They both fall within the determination of the case phase of the hearing, as understood by Rule 14 of the rules. So it's that part of the inquiry which is dealing with the determination of the case, and so it includes whether the registrant's fitness to practice is impaired, and if so, what sanction to impose, and in appropriate cases going on to consider whether an immediate order is necessary. And so what one has left then is his final point, that they're susceptible to different mechanisms of challenge. Again, our submission is that doesn't create a distinction that means that to treat them as a concurrent suspension or one suspension is wrong. In terms of the language of the statute, so this is now section 30 subsection 3, so this is authorities bundle, page 20. It is reasonable to conclude that, to decide that start and take effect have different meanings. Take effect, I accept for the purpose of section 29A, the taking it, that makes perfectly good sense. But when one comes to section 30, section 30 is using different language because it's directing, it's ordering that registration shall be suspended forthwith. That's section 30, subsection 1. Section 30, subsection 3 explains when the order starts, because it starts from the time when the order is made.
Until the time when the direction takes effect.
That's how, yes.
Why do you say this is different language?
Because it's indicating when the suspension starts. So it's indicating it starts either forthwith or when the order is made, which is for these purposes the same thing. And in the same way that section 30 doesn't provide for one to be set off against another, and I accept that, nor does it indicate, in terms at least, that they are additive or to be served consecutively. And so the judge was right, or at least not wrong, to conclude that this was one period of suspension. And the taking effect provision is simply indicating, as he put it, which piece of paper, and I paraphrase wrongly, is operative.
Aren't you in danger of, with that last submission and this submission, aren't you in danger of accentuating the different approach by the use of different language? Section 30, where the order is that the registration should be suspended forthwith, and the order operates from the time it's made, to what we saw earlier, which is the use of the word take effect, which must mean the same wherever it's used, 29A.
That may be it tends to accentuate that. But that is the language of the statute. It's telling us when it starts.
Well, the one thing that nobody says is starts. Apart from Mr. Justice Ritchie.
Well, to be fair start does appear in section 33, subsection 4.
33.
33, so it's page 25, over the page to 26. This is what my learned friend relies on as the set-off provision.
Okay, thank you.
It's my fault, I just haven't found the word. What
It's
is it?
the penultimate line of subsection 4. That further period shall be treated as having started on just over the page on page 26 to run at that time. So, is it helpful just to deal with how some of the points Mr. Justice Morris picked up in Daniel?
That's up to you.
Well, if I can just deal with, take you there, please. So,
It's divider 13.
thank you. And it's page 291, paragraphs 253 and following.
Well, that's really the entirety of his determination in respect of
This issue, yes, indeed. Some of this I've already dealt with. So I've 255 and 256, where he disagrees with that start and take effect mean different things. As I say, on a reading of section 30, they can be said to amount to different things, and that produces a result that is, in Mr. Justice Ritchie's analysis, consistent with the statutory maximum, or not inconsistent with the statutory maximum. 257, I've touched on in terms of, I accept obviously that the statement is, as he puts it, highly persuasive, but it's relevant to bear in mind what the actual outcome was, which was that the Supreme Court felt it was appropriate to impose 4 months rather than 12 months. His fourth point, 258, no reason in principle why an immediate suspension order cannot be for a longer time than the underlying substantive direction. And then he points to the nursing and midwifery order, which allows 18 months. That might be an appropriate conclusion in a nursing and midwifery case. But the only statutory maximum that is provided in a dental case is 12 months, whether substantively or resumed, subject to the residual power of indefinite suspension. But that's not relevant here. And so when he says at the foot of 258, Parliament has chosen not to impose a cap in the case of other professions, including dentists, that would have to be read in light of the power conferred by Section 27B, 6B, so the 12-month maximum. That's the only statement of maximum in the Act. Um, 259 is correct. So section 33(3) provides a form of set-off for the reasons that the learned judge explains there. It's subject, ironically, to a proviso that if you don't appeal, that set-off doesn't apply. But then you have to go back to section 27C, which tells you that the suspension starts from the time when the previous suspension ended. So it's a set-off only which is only effective for those who appeal, but not for those who don't. And the risk that he adverts to in 260 of a registrant being able to go back to practice without a review is something that can be addressed by, as I indicated to Lord Justice Stuart-Smith, by the council seeking a review of the suspension, if you regard it as one suspension, seeking a review of the suspension before it expires, notwithstanding that the appeal has not been concluded.
Can you just tell me which provision in the Dental Act or in the rules provides for that right for the power to review? The one you've just described there. Or do it after the short adjournment?
As I indicated earlier, there's nothing in the Act which confers a power to direct a review.
Confers power on the GDC.
On the GDC to direct a review. And there's nothing in the rules which deals with that either. It's the practice which has been adopted, and the practice which is encouraged by the guidance, or at least they're encouraged to consider a review.
This is the 2016 guidance now, is it?
The 2016 guidance, yes. What the rules provide is for various notice periods and the mechanism and procedure for conducting a review hearing. So it would seem to us that implicit within that is that there is a power to order a review, order or request a review, and this potential is against me whether it's been ordered in the first place.
Is that a convenient moment?
Yes.
Right, thank you. We'll resume at 2 o'clock.